Well, so far we've looked at some of the general recommendations in the framework. Cheryl, can you tell us a bit more about the specific domestic violence recommendations in the framework?
Yes, of course. The framework refers to the experiences around the world with countries drafting and then implementing these laws on violence against women. So there's actual examples that are provided in the framework on domestic violence legislation that works, and it really does focus on, discusses best practices and lessons learned. The domestic violence portion of the framework recommends that there be a clear definition of what domestic violence is.
Very important.
Very important, that it include intimate partners and family members as those who can access the law. It should apply to both past and present intimate partners, members of the same household. Like we talked about before in the general recommendation, the law should have a very clear mandate about prevention efforts. This is especially critical in domestic violence cases because there's such oftentimes a bias about domestic violence being a private family matter.
Absolutely. And courts as well.
Exactly. Yeah. Not something that governments and courts and police should be intervening in. So that's very important in the realm of domestic violence, that there be a really clear prevention strategy in the law. And then also the domestic violence recommendations focus on protection, support, and assistance to survivors, like we talked about in the general recommendations. The domestic violence section in those recommendations have provisions that relate to both criminal law and civil laws. Very important in domestic violence cases. One of the focuses is the critical role of law enforcement. Police, law enforcement are on the front line of domestic violence cases. People embarking on this legal reform in their countries will oftentimes begin to understand that police are very aware of domestic violence issues. Not all police, of course, but many are very acutely aware of the damage that it causes to women and children and the community. But they do need clear guidelines on how to deal with it, and that should be directly in the law.
There seems to be a global pattern of a reluctance to intervene. So you're talking about very specific mandatory actions that they must take.
Absolutely.
When they get a report.
One of those that the expert group identified has been an important practice in domestic violence legal reform has been the requirement that police write a report at the scene of an assault, do some kind of risk assessment at the scene of assault to make sure they don't have a very dangerous situation on their hands, a possible imminent homicide, that they transport her to a medical facility or shelter if possible. Those criminal provisions, those recommendations in the domestic violence section emphasize the importance of prosecution of domestic violence crimes. No matter the level of injury, the state should take responsibility for prosecuting these crimes.
Cheryl, what about if the complainant, victim, changes her mind halfway? What does the framework say about that, about prosecuting or not?
Unfortunately, that's a very common in domestic violence cases. Victims are oftentimes, they may be threatened by their abuser. If you testify, I will do this. And it's a very frightening process. It can be a very shameful process, or feel very shameful to a victim survivor. So that does happen, where victim survivors are reluctant to testify, to face their abuser in the trial. So there have been strategies around the world. We call it evidence-based prosecution, absent victim prosecution in the United States, where prosecutors learn and law enforcement learn to gather evidence that supports their case of prosecution of an abuser without the victim testimony. It requires resources. It requires training. It requires a real careful directive to law enforcement about how to get the evidence, how to take the pictures and assess the scene and document that this particular assault took place.
Cheryl, what about the so-called patterns of reducing the sentence in honour crimes, or where customary forgiveness has taken place, or where compensation has been paid? What does the framework say about that?
The framework is very clear about that, sentencing reduction should absolutely be eliminated from laws in the cases of so-called honor killings. It should make clear that an abuser's offer to marry a victim shouldn't exculpate that abuser from criminal penalties that are commensurate with the crime.
This becomes particularly important in countries where they have parallel legal systems or religious courts.
Exactly.
So this is an enormous challenge. Can we now move to the issue of civil protection orders and so on, Cheryl?
Right, exactly. Just one last thing about the criminal. I think one thing that's proven successful around the world is to make sure with sentencing and penalties in domestic violence cases is that with repeat incidences of assault or violations of orders of protection, which we will talk about in a minute, those penalties should increase to make clear the seriousness of that. And yes, let's talk about civil laws now, a really important part of domestic violence legal reform. So many countries around the world right now are including remedies in their civil laws, an order for protection remedy, which allows a victim survivor to come forward and seek an order from a court, and sometimes from law enforcement. In some parts of the world they're doing it that way, which orders the abuser to stay away from the victim, sometimes to stay out of the home. The permanent orders can order things like alimony and child support and payment of rent and payment of insurance and bills. It's very important, we think, the expert group recommended, and this is in the framework, that legislation include a possibility of an emergency order that can be issued ex parte without a hearing.
The person being there.
Right, and the victim can come forward and make a clear statement about the violence or the fear of imminent violence and get that order immediately. And then, of course, due process protections are very critically important.
Yeah, no, you're right. In fact, we used the model framework in Vanuatu in that context and put a provision in that said, if you're a woman on the outer islands and you don't have access to a court, you can ring in for an ex parte order. So now there's a provision to make those types of orders.
Exactly, or authorize law enforcement at the scene of an assault to do that. And then, of course, as I was mentioning, recognize those due process rights of everyone and get that hearing scheduled if it's requested by the offender, by the abuser, and get that hearing scheduled, and then the authorities can decide on a permanent order. Very, very important remedy, these orders for protection in cases of domestic violence. It has been shown to be one of the most important, effective legal remedies that we've found in these cases.
Cheryl, what about the links between domestic violence and family law here? For example, does the fact that the court has made an order against a perpetrator, does that affect the ability of either party to get custody of children?
The custody of children issue is a very, very important and complicated one that the legal system has to carefully think through. It has been shown in many jurisdictions that abusers may use the custody of the children to either get access to the victim or to prolong a process or to manipulate a process. So the custody of the children is just a very important issue. There should be very clear screening in divorce cases and family law cases for violence. Judges and other authorities, magistrates, should be very aware when there's children involved and custody involved about the possibility that there's violence and that there's power and control possibly being used by an abuser. The framework recommends that legislation should address custody, temporary custody, at the order for protection hearing, and that there really be presumption of custody with non-violent offenders.
Yes. I think, in fact, the framework makes a very good argument that the only best way to approach this whole issue is an integrated approach. One that deals with the criminal aspects of domestic violence, one that deals with the family law aspects, which are so critical.
Exactly.
So many women stay in abusive relationships because they have no legal rights to children, property, financial support after separation. And so if the law does not deal with this in a comprehensive, integrated way, it really won't provide any effective solutions, will it?
The framework, exactly, and the framework does actually address that and talks about the courtrooms around the world that have been created, the dedicated domestic violence courts that integrate all those issues as you talk about family law and criminal law.
Thank you, Cheryl. Thank you for that excellent, those excellent comments on domestic violence.